If you keep up with any copyright blogs like I do, you probably have heard about copyright termination. This topic also goes by the name copyright recapture or reclaiming copyright, but everybody is talking about the same thing. I'll try to summarize the concept. Authors, for example songwriters, of older works that assigned, transferred, or granted their copyrights away, can terminate that grant and recapture their copyright, so that the author is once again the owner. There are two main provisions in the Copyright Act that lay out in excruciating detail the procedures to take to terminate a copyright grant, but I hope to give you some practical knowledge about the subject. The first thing to remember when dealing with termination is that publishers and labels are not the author's friends here. While the law may enable authors to recapture their copyrights, labels and publishers don't want to give them back. If a songwriter wants to get back her copyrights from a transfer made back in 1978, for example, a simple letter to her publisher that says, "Please give me back my copyrights tomorrow," is not going to do the trick. I want to talk briefly about several categories of grants and briefly explain how and when to terminate a copyright grant of those works. When I say grant, I mean transfer of copyright ownership. It can be called a grant, an assignment, a transfer, etc. The first category. For grants made before 1978, the author may terminate the grant effective within a 5-year window beginning at the end of the 56th year after the date copyright was secured. If an author misses this first window after the 56th year, Congress gave authors a second bite at the apple, which 5th-year window begins at the end of the 75th year after copyright was secured. Second, for grants made after 1978, termination of the grant may be effected at any time during a period of 5 years beginning at the end of 35 years from the date of execution of the grant, or, if the grant covers the right of publication of the work, the period begins at the end of 35 years from the date of publication of the work under the grant, or at the end of 40 years from the date of execution of the grant, whichever term ends earlier. That seems like that should be the only two categories, right? Before 1978 and on or after 1978. Congress seemed to have thought so too when they drafted the law, but they left a gap. If a grant is made before 1978, but the work that is subject to the grant is created on or after 1978, the law is not so clear about what to do. And so if it wasn't already evident that you should get a lawyer to handle this termination stuff, this gap should make it clear. Not only do different termination windows make copyright termination complicated, the procedures are also quite complex. For example, to terminate the grant, the author must serve notice upon the grantee, often the publisher or label, not less than 2 years before the effective date of termination and not more than 10 years before it. Courts of law are currently dealing with a number of cases where authors have attempted to terminate their copyright transfer, and the parties on the other side of those transfers never seem to want to give the copyrights back. You wouldn't believe the number of issues that can come up. In conclusion, authors of older works should take advantage of their right to copyright termination, especially if the works still have value. But authors need to make sure that the process is done correctly.